I have seen people deny receipts while holding the receipt in their hand. I have seen people argue against photographs, signatures, timestamps, and even their own text messages. But there is one kind of denial that still unsettles me after all these years on the bench, the denial that survives even when the truth is already on screen. That is exactly what happened when Karen Miller walked into my courtroom. She was a store manager, a respected one according to her own words. She wore a black blazer, a silver name badge, and the tight expression of someone who believed authority came from a job title. Before the case began, she stood at the defendant's table with both hands folded in front of her, looking around the courtroom like she was inspecting employees, not citizens, employees. That told me something before she ever spoke. Across from her stood Rachel Adams, a young single mother who worked nights at a hospital cafeteria. Rachel looked exhausted in the way people look when they have had to explain the truth too many times to people who refuse to hear it. In her hands was a small envelope, receipts, photos, a printed complaint. Nothing dramatic, but she held that envelope like it was the only thing keeping her from breaking down. The case looked simple. Rachel claimed Karen's store had sold her a damaged refrigerator, refused the return, accused her of lying, and then banned her from the store when she demanded help. Karen denied all of it. She claimed Rachel had brought in an old damaged appliance and tried to scam the store for a refund. On paper, it was a customer dispute. But the moment Karen started speaking, I knew it was something else. She said, "Your Honor, I manage a professional retail location. We don't make mistakes like this. Customers sometimes create stories when they don't get what they want." Rachel looked down. I watched her hands tighten around the envelope. There it was, the first wound. Karen was not only denying the claim, she was attacking Rachel's character. That is a common strategy when evidence is coming. If you can make the victim look dishonest early, maybe the truth will sound weaker later. I asked Rachel to explain. Her voice trembled, but she stayed clear. She said she bought the refrigerator for her apartment after saving for 3 months. When it arrived, the lower corner was crushed, the door seal was torn, and the inside smelled like chemical cleaner. She called the store the same day. Karen said she never did. Rachel handed me the receipt. Karen smiled. "That proves she bought something," Karen said. "It doesn't prove it was damaged." The courtroom was quiet. Then Rachel handed over delivery photos taken outside her apartment. The refrigerator was still wrapped in plastic. The crushed corner was visible. Karen leaned forward, looked at the photo, and said, "That's not our unit." "Not our unit." No hesitation, no curiosity, just denial. I have learned to be cautious when someone rejects evidence too quickly. Truth usually examines, lies swat. I asked Karen, "How can you know that from this photograph?" She said, "Because I know my inventory. That confidence could have impressed a courtroom if it had been real." Then Rachel opened her envelope again and pulled out one final paper. A delivery label, store name. Order number, date, serial number. Karen's expression changed for half a second. Only half a second, but I saw it. And then Rachel said quietly, "Your Honor, the serial number matches the store record." The gallery shifted. Karen's smile disappeared. And that was when I realized the case was not about a damaged refrigerator. It was about what Karen was willing to deny, even after the proof was already in front of her. When Rachel Adams said the serial number matched the store record, Karen Miller did not look surprised. She looked annoyed. That difference matters. Surprise belongs to people who discover something new. Annoyance belongs to people who realize something they hoped would stay hidden has just become harder to deny. I asked Karen to look at the delivery label carefully. She barely glanced at it. "That label could have been moved," she said. The gallery shifted again. Rachel closed her eyes for a second, and I understood why. She had clearly heard this kind of answer before. Every time she brought proof, Karen moved the goalpost. Every time Rachel answered one accusation, Karen invented another. That is not disagreement. That is a strategy. Karen told the court that Rachel had been aggressive in the store, that she had yelled at employees, and that she tried to intimidate them into approving a fraudulent return. Rachel shook her head, but she did not interrupt. That restraint interested me. People who are lying often rush to fill silence. People who have been dismissed too many times sometimes stop expecting anyone to believe them. I asked Rachel what happened when she returned to the store. She said she came with the receipt, delivery photos, and the warranty booklet. She asked to speak with a manager. Karen came out, looked at the paperwork, and immediately said the store was not responsible. Rachel said, I asked her to check the order number. She said she didn't need to. Karen interrupted, because I knew it wasn't ours. I looked at her. You will not interrupt. Her face tightened, but she stopped. Rachel continued. She said Karen accused her of switching the appliance, told employees not to help her, and then had security escort her out while other customers watched. That detail changed the emotional weight of the case. A denied refund is frustrating. Public humiliation is different. I asked Karen if Rachel had been escorted out. Karen said she was removed for disruptive behavior. I asked, was there a written incident report? Karen hesitated, only briefly, then said, there should be. There should be. Not there is, not yes, there should be. That told me the report either did not exist or did not say what she needed it to say. Karen then attempted to regain control. She straightened her blazer and said, Your Honor, I have worked retail management for 15 years. I know when someone is running a scam. There it was again, authority without evidence, a title being used as testimony. I have seen it from business owners, supervisors, landlords, and executives. Some people believe their position makes their version of events more believable than another person's pain, but court does not work that way. A title does not outrank a fact. Rachel then produced call logs showing she contacted the store within 2 hours of delivery. She had also emailed customer service the same evening with photos attached. Karen said, corporate never sent that to me. Rachel quietly replied, you responded. The courtroom went still. Rachel handed over the email chain. Karen's name was at the bottom, Karen Miller, store manager. Her response was short, return denied. Customer damage suspected. I looked at Karen. Did you write this? For the first time, her answer slowed. I may have, another shelter word. Then Rachel's attorney asked if the court could review one additional piece of evidence from the store's own system. Karen's eyes moved sharply toward him. What evidence? Her voice had changed. It was not loud anymore. It was careful. Rachel's attorney said, the customer service call recording. Karen's face lost color, and in that moment, I knew the cameras were not the only thing about to catch her lie. A recorded call can reveal what paperwork cannot. Paper shows decisions. A voice shows attitude. And when Rachel Adams's attorney mentioned the customer service call recording, Karen Miller's confidence changed shape. She did not object immediately. She did not laugh. She did not attack Rachel. She became still. That kind of stillness tells a judge something. It means the person is no longer thinking about truth. They are thinking about damage control. I allowed the recording. The courtroom speakers crackled for a second, and then Rachel's voice came through. Tired, polite, nervous. Hi, I received my refrigerator today, and it's damaged. I have photos and the delivery label. I just need help with the return. Then another voice answered, Karen's voice sharp. Professional on the surface, but cold underneath. This unit was inspected before it left our warehouse. Rachel said, but I have photos from the delivery. Karen replied, photos don't prove what happened after delivery. The gallery became very quiet. Rachel stood with her eyes lowered, listening to herself being dismissed all over again. That is one of the hardest things in court. Victims sometimes have to relive the moment they were not believed before they can finally be believed. The call continued. Rachel said, can you at least check the serial number? Karen answered, I don't need to check anything. I know how these things work. That sentence landed heavily, not because it was loud, because it exposed the entire problem. Karen had made up her mind before reviewing the evidence. I looked at her, but she avoided my eyes. On the recording, Rachel's voice began to shake. I saved for months to buy this. I can't afford another one. Karen said, that is not the store's responsibility. Rachel's attorney paused the recording. Then he handed over the store's own return policy. It clearly stated that damage reported within 24 hours of delivery had to be inspected before denial. I asked Karen, did you order an inspection? She said, it was unnecessary. I asked again, did you order an inspection? This time, she said, no. There it was, the first direct truth of the morning, small but important. Karen had denied the return without following her own store's procedure. Then the attorney resumed the call. Rachel asked, can I speak to corporate? Karen said, corporate will send it back to me. I am the manager. I watched Rachel's face as that line played. She looked humiliated even now, because that was the moment Karen had made the store feel like a locked door. Not a business, a kingdom. Then came the part Karen did not want heard. Rachel said, I'm coming in with the receipt and photos. Karen replied, If you come in making accusations, I'll have security remove you. Rachel said softly, I just want what I paid for. And Karen answered, then maybe next time, don't damage your own appliance. A low murmur moved through the courtroom. Karen finally looked up and said, that was taken out of context. I leaned forward. The court just heard the context. She said nothing. Then Rachel's attorney said, Your Honor, the store cameras show what happened when Rachel came in. Karen's hand moved to her name badge, a small, nervous movement. I noticed it immediately. The screen turned on again. And before the footage even played, Karen whispered, The cameras don't show everything. That was a strange thing to say. Because no one had claimed they did. And when someone starts explaining evidence before evidence appears, it usually means they already know what the room is about to see. Store cameras are different from human memory. They do not protect pride. They do not soften behavior. They do not forget the part someone wishes never happened. When the footage appeared on the courtroom screen, Rachel Adams stood completely still. Karen Miller crossed her arms, but the movement looked defensive now. Not confident. The video showed Rachel entering the store at 6:18 p.m. She was carrying a folder in one hand and holding her phone in the other. She did not rush. She did not shout. She walked directly to the customer service desk and waited while an employee finished helping another customer. That mattered. Because Karen had described her as aggressive from the moment she arrived, the footage showed something else, patience. The employee spoke to Rachel. Rachel showed the receipt and photos. The employee looked concerned, picked up the phone, and called someone from the back. Then Karen appeared. Her posture on that screen told the whole room what the audio had already suggested. She walked out with her arms folded before Rachel even finished explaining. A manager should investigate before judging. Karen judged before listening. The footage had no audio, but body language can speak clearly. Rachel held out the delivery label. Karen barely looked at it. Rachel pointed at the serial number. Karen shook her head. Rachel showed the photo on her phone. Corin turned away. The gallery became silent. I looked at Karen and asked, Is that you refusing to examine the label? She said, I was busy. Not no. Not that is inaccurate. Busy. Another excuse trying to stand where truth should have been. The footage continued. Rachel remained calm. She did not wave her arms. She did not lean over the counter. She did not threaten anyone. Then Karen pointed toward the front doors. A security guard approached. Rachel stepped back, confused. Her face on that video was difficult to watch. She looked embarrassed. Not angry. Not dangerous. Embarrassed. That is something people like Karen often underestimate. Public humiliation leaves a mark. A person can recover from losing money. It is harder to recover from being treated like a criminal while strangers watch. Then the footage showed Karen speaking to the guard. The guard looked at Rachel, then at Karen, then back at Rachel. Even he appeared uncertain, but Karen pointed again. Rachel gathered her folder slowly and walked out. No yelling, no scene, no disruption. Just a tired woman being removed because a manager had decided truth was inconvenient. Karen said, The camera doesn't show what she said. Rachel's attorney immediately handed over the security desk incident log. The guard had written, Customer was calm. Manager requested removal due to return dispute. The courtroom shifted. Karen's story was collapsing from every direction. Call recording. Policy.mam, camera footage.curity log. And still she tried to deny. That is when I realized something deeper about Karen Miller. She was not simply protecting the store. She was protecting the version of herself that never made mistakes. Some people cannot admit they were wrong because their identity depends on always being right. Then Rachel's attorney asked permission to play footage from the loading dock. Karen's face changed. The loading dock. That was not customer service. That was before delivery. Before Rachel ever received the refrigerator. Before any alleged customer damage could happen. I looked at Karen for the first time. She did not have an answer ready. The screen changed. A warehouse camera appeared. A refrigerator wrapped in plastic sat near a delivery truck. And then the courtroom saw an employee push it forward, straight into the metal edge of the loading ramp. The courtroom saw the refrigerator hit the metal edge of the loading ramp, not after delivery, not inside Rachel Adams' apartment, not because of anything Rachel had done, before it ever reached her. The impact was clear. The lower corner struck the ramp hard enough to bend the frame beneath the plastic wrap. One warehouse employee stopped. Another looked over. For a few seconds, both men stared at the damage. Then one of them pulled the plastic tighter around the corner. The gallery reacted at once. Rachel covered her mouth. Karen Miller did not move. That was the moment the lie became visible. The cameras had caught what Karen denied from the beginning. The footage continued. A supervisor walked into frame, wearing the same black blazer, same name badge, same controlled expression. She looked at the damaged corner, spoke to the employees, then checked something on a clipboard. One employee pointed toward the refrigerator. Karen shook her head and gestured toward the truck. The damaged unit was loaded anyway. Rachel began crying quietly, not because of the refrigerator, because she had spent weeks being called dishonest for telling the truth. I looked at Karen and asked, "You saw the damage before delivery?" Karen stared at the screen. "I don't remember that." The courtroom shifted. Not again. That excuse had collapsed too many times already. Rachel's attorney then played the final 30 seconds. Karen's voice came through from the warehouse camera audio. "Send it. If she complains, say it was customer damage." The courtroom erupted. I struck the bench once, and then silence. That was the viral moment, not a dramatic confession from the stand. Not a screaming argument, just a store manager's own voice, calmly planning to blame a customer before the customer had even received the product. Karen's face drained of color. Rachel looked at her and whispered, "You knew." That whisper hurt more than shouting would have, because it carried the weight of every phone call, every ignored email, every humiliating moment at that customer service desk. Karen finally said, "I was trying to protect inventory loss." I looked at her. "No, Mrs. Miller, you were trying to protect yourself." That sentence landed hard because everyone in the room understood it. Karen had denied the proof. Then the cameras caught her lie. I ruled that Rachel was entitled to full reimbursement, delivery costs, replacement costs, court fees, and compensation for documented losses caused by the store's refusal to follow its own policy. But before I finished, I looked directly at Karen. A manager's title does not give you the right to turn a customer into a scapegoat. Karen lowered her eyes. For the first time, she had nothing clever to say. Then Rachel's attorney submitted one final document. An internal email Karen sent after Rachel filed the complaint. It read, "Do not mention loading dock footage unless corporate asks directly." The room went cold again, and I knew the case was not only about a damaged refrigerator anymore. It was about a cover-up. I have seen many people make mistakes in court. A mistake can be corrected, a bad decision can be admitted. But a cover-up is different. A cover-up shows that at some point, a person had the chance to choose honesty and chose protection instead. Karen Miller sat in front of me with her hands folded tightly on the table. Her name badge still said store manager, but by then, that title had lost all meaning inside my courtroom. Because leadership is not proven by authority. It is proven when the truth costs you something, and Karen had failed that test. Rachel Adams stood across from her, wiping tears from her face. She did not look victorious. She looked exhausted. She looked like a woman who had finally been believed after being humiliated for far too long. That matters. People sometimes think justice is about punishment only. It is not. Sometimes justice is simply the record saying, "You were not lying." I ordered the evidence forwarded to the company's corporate office for review. I also ruled in Rachel's favor for the full damages, including the refund, delivery fees, replacement cost difference, court costs, and documented financial loss caused by the store's refusal to follow its own return policy. Karen tried one final time. She said, "Your Honor, I was making a management decision." I looked at her and said, "No. You made a dishonest decision and then used your position to punish the customer who exposed it." The courtroom stayed silent. Rachel lowered her head. Karen had no answer. That silence told me the truth had finally reached a place her denial could not follow. Before I closed the case, I looked at Rachel. I said, "Miss Adams, you brought receipts, photos, calls, emails, policy records, logs, and video. You did not create chaos. You brought evidence." Her eyes filled again, and I understood why. For weeks, Karen had made her feel like proof did not matter, like a tired single mother could be brushed aside by a manager with a badge and a cold voice. But proof does matter. It may be ignored for a while. It may be delayed. It may be denied. But when proof finally stands in a courtroom, it has a weight lies cannot carry. Karen walked out that day without her confidence. Rachel walked out with her name cleared and her money restored, but the lesson stayed with me longer than the ruling. A position of authority does not make someone honest. A title does not make someone right. And denying the truth does not erase the cameras watching from the corner. Karen Miller thought she could control the story because she controlled the store. But the courtroom does not care who has the bigger office, the louder voice, or the stronger title. The courtroom cares about what can be proven. And on that day, the proof was simple. The customer told the truth, the manager lied, and the cameras caught everything.